Welcome back if you're just joining us. This is Sunday edition here on KTN News. This is Kenya's only Sunday morning political show. Let's now switch our attention to the Supreme Court judge. That is the Deputy Chief Justice Philomena Mwilu, who was arraigned in court last week, arrested actually. And let's begin with the latest, being a trove of email that have gone to show the ties or the dalliance between the DCJ and Imperial Bank. Let's get more from our senior political affairs reporter, Duncan Hyamba.
Deputy Chief Justice Philomena Mwilu's defense team has finally managed to rescue her from the Director of Public Prosecution's noose, abruptly halting her prosecution from alleged abuse of office and corruption-related offences. The Anti-Corruption Court has accepted High Court orders to stay the matter, at least for now. Her 34-man defense team successfully managed to wiggle her out of taking in what was a career-threatening plea on 13 counts leveled against her.
In compliance with the said order, this Honorable Court gives the following directions: that this proceeding shall now rest at the point at which they are reached, that the status quo shall be maintained in respect of any orders the court had made so far.
Among other things, Mwilu is accused of forgery, tax evasion, and abuse of office in relation to commercial transactions with the collapsed Imperial Bank, a move the DPP has vehemently opposed.
Experienced to see the difficulties and the challenges prosecutors face in prosecuting high-profile cases. And when we say that the cases are not moving, it's not because of us. It is our law, it is our constitution, which we must abide by.
Lady Justice Mwilu obtained the orders after arguing that her being taken to court is part of a scheme by President Uhuru Kenyatta to avenge her vote for nullifying the 2017 August 8th presidential election. In an affidavit filed in court by the Okongo Mogeni and Company law firm, Mwilu is quoted as saying, immediately following the determination of the Supreme Court of Kenya in the 1st September 2017, on the same day, none other than the President of the Republic of Kenya, Uhuru Kenyatta, made public statements issuing both explicit and implicit threats against the majority of judges who decided the outcome of the presidential petition. The affidavit goes ahead to say, I verily believe to be true that the fact that charges brought to me, though fashioned as corruption and economic crimes, were in fact investigated and filed through the office of the Inspector General of Police, over whom the first respondent exercises constitutional powers of control and direction. Based on that principle, the prosecution against me cannot stand, having been tainted by illegalities from the start. On Thursday, the Deputy Chief Justice reported for duty as usual, as confirmed to KTN by Chief Registrar of the Judiciary, Ann Amadi, a confirmation that until October 9th, Philomena Mwilu continues business as usual. It is a huge sigh of relief for the Deputy Chief Justice Philomena Mwilu after her team of 34 advocates successfully rescued her from the DPP's noose. For now, she remains afloat. But for how long will this last, or will she still be dragged before the legal gallows? Duncan Hyamba, KTN News.
All right, let's begin from that affidavit by the DCJ Dismas, and she's making these accusations against the president to the effect that this is a witch hunt. What do you say to this?
Well, you know, there is certainly that Philomena knows quite a lot that all of us do not know. But when you're looking at the larger picture, yes, is an issue of corruption. And in my view, the DPP has made a strategic error in his judgment. That in as much as we want to fight corruption, it should have a priority matrix. Because majority of Kenyans right now are not really worried about the personal commercial transactions of an individual judge, but they're worried over massive corruption at Kenya Pipeline corruption. They're worried of corruption at Ruaraka. They're worried of corruption over the importation of sugar to Kenya. And they're just worried that a third of our budget disappears into public servants' pockets. That, in my view, should be the priority. And that's where the DPP should be looking at. Number two, Chapter 6 is very important. And I guess that's how the DCJ comes in. And it's on, if you look at history, you look at jurisprudence, and you speak to lawyers who are highly regarded in society, they say, if you want a court in Kenya to entertain a criminal matter on a judge, then you go through the Judicial Service Commission. Let the Judicial Service Commission handle the matter, then they'll request the judge to resign or they fire him, whatever they want to do. Then now, as an ordinary Kenyan, as a Wanjiko, as a Mura, then you can arraign that person before court. It's a best practice. There's even a case quoted from Nigeria that if you want to take a judge through a criminal proceeding, make sure there is no longer a judge, then you can go through the process. If you look at the Chief Magistrate, Lawrence Mugambi, he finds himself in a very awkward, almost intimidating position. Essentially, you've got your boss before you. How do you prosecute this? And I would easily bet my head that if it was a normal Wanjiko arrested, he would have not been out on a personal bond of 5 million. But Mugambi found himself before the boss. And what can he do? For all practical purposes, it doesn't make sense. And in my view, we should look critically at what the DPP is saying and pat him on the back for fighting corruption, but the review is priorities. Because when you look at Justice Mwilu and the issue, while we know that judges in Kenya are supposed to be like Caesar's wife beyond reproach, but this is a commercial transaction, and I don't know whether or not Imperial Bank is actually aggrieved. Because if there's somebody who's supposed to be pursuing this matter, it's supposed to be Imperial Bank. So this is something which can be sorted out in a civil way or in an administrative manner. I mean, no way suggesting that Mwilu would be innocent because we don't have all the material facts.
Yes.
But looking at the resources at the DPP's disposal, priority should be on this massive corruption. I mean, the DPP is running after 12 million that Mwilu is accused of and is letting 1 trillion disappear into people's pockets. If you do a basic opinion poll that Kipchumba doesn't like by Ipsos as to whether we should be going for this 12 million or going for 1 trillion, I suspect majority of Kenyans would say, let's go for 1 trillion. Right. But be that as it may, the integrity of public officials must be highly respected. I mean, like these emails, what they seem to suggest is that she used the social capital to have decisions made in her favor.
Right.
She used her position in society to get a relative or somebody employed at Imperial Bank who was acting as a special purpose vehicle. But in my view, the DPP, if he has a priority matrix,
yes,
go for Ruaraka, go for these guys who made erroneous decisions on killing our sugar sector. I mean, Makia would be reluctant to admit that his neighbors back in the village are using sugarcane for firewood. Others have committed suicide because of erroneous decisions taken by Rotich.
That's more important than
the same Rotich who's taking decisions so that we have a 16% increase on fuel cost is the same Rotich who allowed Tom, Dick and Harry to import sugar to Kenya without consideration to quality or even quantity. Right. In fact, this is the time we are supposed to be looking for Rotich and look at him in there and ask him, whose interest does he serve in Kenya?
Good question. Mark, 2 questions for you. What do you think is the net effect of the fact that the DPP went for the DCJ via these criminal charges rather than through the Judicial Service Commission like it was done for Justice Philip Tunoye? And number 2, do you think the DPP is unfocused in his fight against corruption?
I have pondered this question for a while. And the reason why I've pondered it is it's got very many interesting angles. First, I always look at things first from my strongest suit, which is communication strategy. The message you send to the judiciary when you hit that high is that, you know what, I'm coming for you next, which is sort of like going into prison and punching the biggest bully in the face. It has that effect of shaking up the judiciary. Now, it is no secret to any Kenyan that in this country we felt for a long time that justice is bought, it is not served in this country. So there is that aspect. My second aspect and thought is I think of the case of one Alphonse Capone, as Trump will call him, but better known as Al Capone. Al Capone was sentenced for tax evasion. Not for prostitution, not for bootlegging, not for drug trafficking, but they found the least item they could pin him on and got him arrested, because it was more important to remove Capone from the streets of Chicago at whatever cost. So my question then is the DPP looking at this in that perspective? Because to me, and I'm not a lawyer, but when I read those charges, they did not seem quite heavy. But then there's also another question. If the charges are frivolous, if the charges are more civil than criminal in nature, my question is, why then do you need 44 lawyers? If for example, I'm accused of stealing Dismas's car, and I know I did not, then logic dictates that I will look for the cheapest lawyer, because there is not much to
Many would argue that
myself
the
on.
DCJ should go for the best defense.
No, but I'm getting there. Now, my question is, if you're innocent and the charges are frivolous and petty, you would not have 44 lawyers, that's one, because that's more lawyers than we had for the presidential petition. So I wonder which is more grievous. And two, you have been Deputy Chief Justice for a number of years. Don't you trust your own judges? Wouldn't you trust the system that you've been at the helm of for so long to be able to process you in a manner that is fair? So to me, the question is not so much about DPP, but the reaction from Mwilu and her team, to me, seems quite suspect. It reminds me of the rumors around the Supreme Court ruling that she was seen sharing some whiskey, and it's called single malt whiskey, and steak with James Orengo. Is this why that she's being defended? Was there some form of play between the one side of the Supreme Court petition? So the questions that arise based on who has come up to defend her actually have eclipsed what the charges are. If I were her, I would have chosen a leaner defense team, and two, I would have trusted the process. I would actually have left the process to happen, because as a judge, she should know whether these charges can stand or not.
All right, speaking of which, let's hear the charges from the Director of Public Prosecutions, Nordin Haji, speaking last week.
The evidence in our possession reveals that, 1, Lady Justice Mwilu abused her office for personal gain, accepted a gift in the form of money in circumstances which undermined public confidence in the integrity of her office, obtaining execution of a security belonging to Imperial Bank Limited, now in receivership by false pretense, unlawful failure to pay taxes, conducted herself in disregard of the law. In view of the above, I have concluded that the evidence is sufficient with a reasonable prospect of conviction, and it is in the public interest that criminal proceedings should be preferred.
Those are the charges as read by the DPP. Hesbon, many would say that the DPP is losing sight of the antelope because of a dashing squirrel.
Well, and I agree with people who hold that opinion. You know, my interaction with a few lawyers in town and prominent ones, some seated next to me, tells me that some of these charges are quite frivolous and they are not of criminal nature. And the fact that we are even listening to this means that you know, the real people that the DPP should be focusing on actually outside there, you know, thinking that they still have a field day to either hide the evidence that would incriminate them. But I think having said that, it's also important to look at these charges as charges that would make sense if we have somebody who is corrupt outside there. And that person is charged as an individual who is corrupt. And I'm not trying to say that the DCJ is either or. What I'm saying is that you may not really appreciate the fact that the second senior most person in the entire judiciary is subjected to the litigation process while she's still holding office. I think to a large extent it gives a very interesting picture of how the judiciary that we are supposed, the Supreme Court essentially, that we are supposed to be holding as a temple of justice.
Right.
And of course, the Supreme Court judges are supposed to be looked at as people who are beyond reproach, you know, because they went through a fairly, you know, rigorous interview process, and we hold them in very high regard. Anything that reaches the Supreme Court is terminal in the sense that the determination that they make.
Yes.
So the whole process of having the DCJ in the corridors of justice as a suspect in a criminal case in itself does not augur well for the credibility and the perception that Kenyans have of the Supreme Court. And you know, you cannot fail to be alive to the fact that there are serious voices that are muted in as far as this case is concerned. The CJ, the Chief Justice himself has refused to comment on this, and you'd understand that, again, it will be dragging himself into bringing the Supreme Court down. And then secondly, you may want to look at what the DPP is doing in terms of what we've had in the recent past.
Right.
We remember the famous statement by the president, you know, when the August 8th election was vacated, that he respects the decision, but he shall revisit. You know, I don't think Kenyans want to wish that away, and there are a number of Kenyans who are thinking that, you know, the fact that we didn't go through the Judicial Service Commission and the attack is on Philomena Mwilu, you know, as a person, of course, holding a very powerful position, brings about some echoes of revisiting. And you want to ask yourself, are we looking at an individual who is corrupt, or we are looking at a team that somebody had promised to revisit? And I think I made that statement here, that when a leader makes a statement in public, the public perceives that leader to be so committed to that statement that he's making.
Okay.
And I think it is just important that the president also comes out and probably says that this is the rule of law.
Right.
But the most important thing that Kenyans probably need to understand is that, you know, the fact that there is a litany of lawyers defending the DCJ does not in any way mean that that case is serious, like Mark is trying to allude. Yes, it doesn't mean that it is serious.
Let me next to your bed in a surgery tells you how serious your surgery is.
Ben, let me tell you, in a defense, any kind of defense or a court of law,
maybe it is meant to intimidate.
No, not really even intimidate. You know, if you go to a court of law, the issues are litigated and their submissions. So you will be found guilty or not guilty based on the submissions. So you cannot say that, this is a simple issue, let them say, I will dismiss, let me have my trust in a lawyer who is not. No. Even in an academic defense, you go with your document, which is very good. But if you ask a question and you say it is very good, it is in that document, you will definitely fail. You will definitely fail.
All right, let's get the view of the lawyer in the room.
Yes.
Kipchumba, I mean, it is Prosecutor Dorcas Oduor versus the likes of Senior Counsel James Orengo, Kalonzo Musyoka, Okongo Mogeni, Dr. John Haminwa, Nelson Harvey, Millicent Odhiambo, all those, to mention just but a few. What does this, from where you sit as a lawyer, what does this point to in this whole DCJ case?
I think we are just a different kind of Kenyans. Every time, instead of looking at the bigger picture, we insist on looking at the frame. Mm-hmm. Is it wooden? Is it plastic? The bigger picture is the arraignment of the DCJ in a court, in a criminal court. Whether
so you're accusing Mark of focusing on the frame.
No.
Mark is the one who brought this.
And let us go back to the
law. Optics.
Whether she had 15 lawyers, all the 8,000 practicing lawyers in the country, or one, we are not addressing the issue. Lawyers under the cab-rank rule have a role or have a duty.
Let's get to the picture.
To the court, a duty to the client, and a duty to the society. If today I'm arraigned before a court of law and I have 10 lawyers or one lawyer, the net effect is one. to a Chief Justice. But going back to the main picture, because we might dwell a lot on the frame and the optics that those are NASA lawyers, there are no NASA or Jubilee lawyers. All lawyers go after clients. If today you are my client and tomorrow your case is over, I have a right to represent your enemy in another case.
All right, we'll get into that. We'll get into that later on. Tell us more about what you see in the real picture of this case.
From where I see the real picture of this case is this: in every journey, in every growth of a democracy, there are missteps and there are bound to be hurdles and bumpy ride as we go and as we grow a democracy. We have seen it happen in the United States with the Manafort case and all that around the Trump issues. It is, for us, we must also allow the gentleman by the name Nurdin Haji some latitude of failure, which does not mean we are condemning him. We should not condemn him. He is not perfect. He is human. But there is a statement that Nurdin Haji gave us which shook my conscience as a lawyer in this country. It shook my ability as a taxpayer. When we say we are going for the cases which will have maximum impact in the shortest period, are we subverting the rule of law? His role is about enforcement of law,
yes,
not about impact. He is not a communication strategist like Bichachi who is after optics. He is a paid public officer who is supposed to ensure enforcement of law. All these other theatrics behind here should not be the case. Addressing ourselves to the issue of DCJ Philomena Mwilu, I think we are splitting hairs a lot in something that is as basic as the color of A and B, simply because we have had presidents. When we go to the case of Ajiwa Ngujiwa versus the Federal Republic of Nigeria, which is a common law jurisdiction, where therefore I am allowed to refer to it.
All right.
The case law there, it was a court of appeal, similar charges, misuse of public office. It was, the holding in the case was such that you cannot drag a judicial officer through a criminal system while they are still holding into the title they have. The best thing will have been this, and we have the constitutional remit in Article 168, whereby you are supposed to take these people through a tribunal, remove them from being judicial officers, deal with them as now ordinary citizens. And this, the predicament at which Nurdin Haji leaves us is this. How do we make this lady to resign as the DCJ? Because ordinarily, and president is there, Tonui was taken through the same system in the bribery allegations, and Nancy Baraza was taken through the same system.
JSC.
What makes Philomena Mwilu an exceptional? That is where the issues of revisiting and all these other issues comes in. And then again, this comes at a time whereby the judiciary has had cuts on their budget. The judiciary, we have had issues around the reconstitution of JSC, where the state actors have refused to gazette the 3 members because of other things.
Hold that thought. We're coming back with that issue. Let me take a look at a couple of texts from you. Moranya Ngorora says, that's neither here nor there. A political witch hunt must be tackled politically. The number of lawyers pro bono show attempts to politicize graft will be resisted, and also to expose the ODPP fishing expedition stands to satisfy political interests. Obunga Apamo says the judiciary fails us yet again. The DPP is somehow right here, but it's hard for a magistrate to be fair against his boss. The DCJ is guilty as charged. Mugambi says, Nicola says, if you can have 44 lawyers representing you, it shows how corrupt you are. Keep those texts and tweets coming. We are taking a quick commercial break, and we're back shortly. When we come back, we'll go to that issue of revisiting. Remember that those remarks by the President Uhuru Kenyatta after the September 1st, 2017 annulment of his election in the August 8th